the law that is going to pinch Kenyans, and it is very fortunate that the Court of Appeal has said no to Section 22 and 23, that is the Cybercrime and Misuse of Computer Act of 2018, amended 2025. Advocate of the High Court, human rights defender, international environmental defender, El Mawi Omar, is in the house just to disseminate good points from this act and this constitution. That is Article 33, 34, and 35. And I put 35 just for a reason, and I will tell you why. It is access for information, studio.
Access to information.
Access to information.
Correct.
So this article is very, very important in this discussion. And I will tell you why as we go on. So not to waste more time, because we only have 60 minutes to discuss all this. Wakili, karibu sana.
Asante sana, ndugu David.
Yes.
It's a pleasure to be here together with you and all of our listeners and people who are watching this important podcast.
Yes.
Where we are going to be speaking about law issues so that people really understand law is not just for lawyers.
Yes.
And if you want to believe this, go and break a law and you'll realize you cannot say that I didn't know that there was this law. Ignorance of law is not a defense, as we normally say out there. So it's important. It's a really good thing that you're doing, and hopefully more and more people can pay more attention to this important subject.
Thank you so much. The last time I saw you, you were international, defending the environmental rights. How just before we start this one, when you compare activism in our homeland and international, which one do you think that the practice is better?
It's going to be, I can't be too simplistic in terms of saying which one is better. There are better things in this side, there are better things in the other side.
Yes.
But I would say all things considered, the international, or probably what we are saying, the developed countries are far ahead of us. And it's justified because these are people who've had democracies. Like if you look at the United States of America, over 300 years, the UK has never been colonized. As it's a very young nation. I think we just barely 60 years since we got independence. So it's much different. There are things that are better there in terms of you can express yourself, you can speak up against government, you can do protests without too much of repercussions from the government side. But here, there are some things when you speak about them, they're being considered as no-go zones. If you start talking about these issues, all of a sudden now, you realize that, as we say in Kiswahili, serikali ina mkono mrefu.
Na popote ulipo itakukamata tu.
Yes.
So tell us what is good inside, within the homeland now.
Yeah, I think for us, what's good is, one, we are seeing more and more people that are really passionate and speaking up about human rights. It's really good to see, if you start at the fundamental document, which is the Constitution of Kenya 2010, one of the most comprehensive constitutions. There are really not many countries that can say have better constitutions than ours. And it's one of the things that people keep saying, it's one thing having the rights, it's another thing to implement them. That's what Wangari Maathai famously, Professor Wangari Maathai, the late, said, that rights are not things that you relax when you've been given on paper. You have to fight for them to make sure that you continue insisting that they remain and become available. So I think it's good. We have really good laws under the Constitution. And that's why you will see attempts of parliament, attempts of other ways of passing laws, because law is not just the Constitution. There are also the acts of parliament, there are bylaws and other laws. Some of these laws have been declared unconstitutional because they're trying to sort of illegalize some of the things that have already been given by the fundamental documents that we have within the country.
And that is perfect. That is the thing. That is the only route that we can start the conversation from, because when you look at the Constitution, the Bill of Rights, Chapter 4.
Chapter 4, yes.
Which is very fundamental. In that Bill of Rights, most of those articles there are not subjected to amendments.
Yes.
If you read it keenly, from the legal perspective, I'm just speaking as a journalist, you will understand that most of those articles in that chapter, the Bill of Rights, are not subjected to the amendment, like other chapters like Article 104 and others that we can subject to their amendment. Now, when we come to the discussion of the day about the Cybercrime and Computer Misuse Act, which was amended in 2018, and later there was also another amendment which was deleting some section clauses and inserting others. The Court of Appeal looked at it and said, no, we are going to infringe these articles and we are going to deny Kenyans their fundamental rights of expressions, which is very, very, very important as we move forward to fight for the democracy. But now, before we look at that, could you please take us through this Article 33 and this Article 34 and then 35 as we start our discussion now?
No, certainly, Brother David. And what's important for people to understand
Yes.
Is that when we passed the Constitution in 2010,
Yes.
one of the most progressive things was the Bill of Rights under Chapter 4 of the Constitution.
Yes.
And that chapter comes before some of the things that we think are very important, including Parliament, including the executive, including many, many things.
Yes.
And therefore, it becomes one of the core sort of issues and things that are being covered in our Constitution. Now, if you look at the Bill of Rights,
Yes.
they are close to about 26 rights and freedoms that are being guaranteed under the Constitution.
Yes.
We can't mention all of them, but some of them are social rights. You're talking about, things like the right to life, assembly, religion, so many rights.
Yes, yes,
But for the purpose of our conversation today, I'm sure you want me to talk about 33, 34, and 35.
Yes.
But before I talk about them, you'll also see that the Constitution has also foresighted that while these rights are being given, there might be reasons why some of these rights can be in some ways limited.
Yes.
But it was also very categorical under Article 25 that there are 4 fundamental rights that come what may, even if it's an emergency situation, even if we are at war, these 4 rights can never in any situation be limited.
Yes.
And these rights, for the purposes of those who are listening and watching, one is the freedom of torture and inhuman or degrading treatment. That's one right that whatever come what may, you cannot limit it. It is guaranteed. You have to give it.
Yes.
The second one is what we are calling the freedom of slavery and servitude. We've left slavery more than 200 years ago. We're never going back there. So there is no justification under any circumstance where someone can be subjected back to slavery or servitude. And servitude here includes forced labor. The third one is what we are calling the right to fair trial. And this is important because it doesn't matter what crime you are being suspected to have done. The law normally assumes that you are innocent until proven guilty.
Yes.
And the only person that can convict you and say, actually, you are guilty, it's through the judiciary, it's through the court.
Yes.
So that right cannot be in any way be infringed. So you cannot just be arrested and be told, we believe you've done this. They have to bring you to court and prove their matter. And that right includes the right to fair hearing and make sure that each party is heard on their beat. And then the last one is what we call the right of habeas corpus.
Yes.
And this also supports the right to fair hearing because it means if you arrest someone, you have to bring them to court. You cannot just arrest someone and refuse. And that's why you will see there are many instances where someone is being arrested, they bring you to court within the next 24 hours, and they try to ask the court to give them more time to investigate.
Yes, to investigate.
And part of me, sometimes I ask the question, if you felt this person has to be arrested, you must have done enough investigation before you arrest them. So why are you investigating after the fact?
Yes.
It's a good thing for them that have not been in the bench in the judiciary. But one of the things I would have asked is, then why did you arrest in the first place? Unless there's justification. For instance, like someone would run away from the country and stuff like that. But otherwise, it should be an exception in terms of arresting someone without concrete evidence around this. Okay. Now to go to the 3 articles that you speak about. The first one.
Before we move, you've discussed about the 3 fundamental rights, which are not subject to any limitation.
4 actually.
4 actually.
Yeah.
And one may ask, why not right to life at some point can be limited? Because there's some of the judgment that I heard from the court that there's still this punishment, death sentence.
Death penalty, yes.
Yes, death penalty. What is the difference between the death penalty and the life sentence?
Yeah, so...
And are they not limiting someone to the right to life? Yeah.
Yeah, it's a good question. So the right to life is normally just guaranteeing that someone has the right to live and that no one will take that right without, I would say, good reason, so to speak. Okay. Now, the problem with saying that the right to life is guaranteed, it means that whatever someone does, you cannot in any way protect yourself. So like right around self-defense. If someone comes to you holding a knife and there's a right to life and you cannot in any way defend yourself, then it means you
can limit his.
Yeah, you have to stay.
Yes.
So that's why you're seeing the right to life here.
Okay.
The other bit is also when you look at aspects to do with delivery, like emergency treatment for women. For instance, if there are complications during the pregnancy and you have to save one life, the mother and the kid. So how does the right to life play here? Although the Constitution says that the right to life begins at birth, not necessarily when you're actually being consumed. It's one of the biggest debates that you saw during the constitution making process for the country. So right to life is important. On the aspect of now the death sentence stroke life sentence, it's something that has been argued a lot in the country. And some of the arguments that people have had is that at a particular moment, the evidence might show that someone has actually committed a crime whereby they're supposed to be convicted to death. For instance, robbery with violence, aspects to do with treason, aspects to do with murder can justify going to death, for instance. But then perhaps maybe there was critical evidence that was not available at that point where someone could have been exonerated. So if you've already killed that person and then later in time that evidence comes out, then actually you see it's an innocent life that has been lost. So it's one of the biggest arguments where people have argued that it's better you do life sentence so that at any part of the time when someone is doing their life sentence, it comes known that that person is actually innocent. Then the law can actually come back and sort of solve that problem that you're having. So that's one of the biggest argument that we are having around the debate on right to life stroke life sentence, not necessarily going towards the issue of right to life itself under the Constitution and why the right to life is not guaranteed under the Constitution.
That is perfectly done. So take us through those three articles, which are fundamental.
Yeah, so as far as our topic today, which is on Computer Misuse and Cybercrimes Act of 2018 and some of the amendments that have come through the year, including 2025, this act really is going to be, as I said, there are laws, articles in the Constitution that can be limited. So there are three laws that actually they're going to be limiting here.
Yes.
There are more potentially, but significantly, these three are what we are going to be speaking about today.
Yes.
So the first one is on freedom of expression, which is Article 33 of the Constitution of Kenya. Now, what that article does, it allows people to speak, to criticize, and in many, many ways find faults without fear. Especially on authorities, and on policies, and also on actions of our elected representatives. I will be using mostly elected representatives in our conversation, not leaders, because normally leaders comes with this supremacy of someone can do anything without checks and balances. But a representative, because someone has voted you to be there, it means you're accountable to them. So this law sort of, if you look at two of the sections, section 22 and 23, it talks about aspects of criminalization of false misleading information, which is published online. And perhaps I should have begun by saying that first, this law, the Cybercrimes and Computer Misuse Act, is an important law because what the intention that they had in mind was that people were being subjected to a lot of harassing, a lot of hacking, a lot of privacy issues online. Nowadays, a lot of our interactions are happening online as opposed to what was happening before. And people were easily doing it knowing that there was nothing that can be done. And therefore, the law is very much needed to try and police some of these wrongdoings that are happening. But if you read the article, the act itself, you realize that they've gone beyond trying to actually deal with these issues around hacking, around harassment, online harassment. But it's actually going towards trying to repress and stopping people from expressing themselves, especially when it comes to things that are against the authorities of the day. That's mostly what you will have in mind. It doesn't say that that in the act itself.
Yes.
But it's actually something that can be used a lot, and you will see we'll be talking about how the Court of Appeal actually agrees that this is something that is happening. So Article 33 is on freedom of expression,
Yes.
which allows people to really express themselves, especially on the authorities, because the underlying principle is that the people who are representing you are accountable to you.
Yes.
And therefore, if they're not accountable, then you have to have a way of actually saying the problems that are happening, right?
Okay.
And you know, may I keep telling people, and I'm sure many people have said, when the government is doing good things, that's well and good, and we acknowledge, but it's not necessarily something that we should say very good about, because that's what they're supposed to be doing. They're doing their job, right? It's like when you provide bread for your kids every day for the next month,
Yes.
no one should come and pat you on the back and say, good job, David,
Congratulations.
because you're doing a good job. No, that's your responsibility. If you don't provide that bread,
Yes.
you know, someone can go to court and actually charge you and make sure that you're forced to actually provide those resources. That's what the government, you have it in place to do.
Okay.
So when things don't go right, then you have to have a way of expressing that. And this article provides that. Now, this law, what it does is how broad Section 22 is.
Yes.
It actually doesn't just talk about people who are doing it intentionally by pushing out false information, or sharing false information or publishing false information, but even people who might be doing it without necessarily knowing that it's false.
Yes.
And this becomes important because under the law, and I will speak about this later, one of the key principles that we say in jurisprudence is that it is better for a guilty person to be free than for an innocent person to be in jail. So what this means is for a guilty person to be free than an innocent person to be in jail. That's why you're seeing even the way our laws are being done and the amount that you have to provide to prove your case.
Yes.
It's not just that person is guilty, but it actually has to be to a point where there's no reasonable doubt. You know, it's beyond reasonable doubt that actually this person has done this, as opposed to what you see in civil cases, where it's more of like a balance of probabilities, where they're saying, is it possible that he actually did it than he did not do it? You know, that this is more of like you've shown more, it's more possible you've done it than not done it, than where someone says there's no amount of any doubt that actually this person has done this crime. And that's why you were seeing the court agreed and mentioned aspects to do with how innocent lives can also be unfairly included. Because even now, in the era of AI, in the era of people being very good at creating a video of showing David actually being somewhere doing something that is very wrong. And if I don't have a degree in, for instance, document engineering and computer science and all that, some of us can be very gullible and actually share that. Knowing that it's true. And you saw it even during the last two elections, not the last election, but the one before, where people are using Cambridge Analytica, for example, using and targeting people, sharing information, saying this person is bad, this is what they've been doing. And there's many people who actually voted with that in mind. So it's not just us who are benefiting from this. Even the people who seem to be trying to push for the implementation of these laws have actually been involved in pushing for these wrongdoings. That is Article 33.
Yes.
Now, if you look at Article 34, it's more on the media and journalism freedom, whereby you'll be able to speak up and report on issues as they are without fear or favor. And what this law does is it's going to do mostly what we're going to be calling self-censorship, where most of the media people now will always be worried that, is there anything here that I'm being told that is not true? Because, you know, even as a journalist, someone can come to you and give you a very good information that something has happened this way, and you report on it. And you might find yourself in the wrong part of the law if someone says actually what you reported on is not true.
It's not true.
What does it mean, you know, for the bloggers, for instance? You will see this case was actually taken to court by the Bloggers Association of Kenya, saying that, you know, like blog posts and stuff like that. What about satirical posts? You know, someone parody accounts where people are using comedy to try and push out a message, but they're very clear in doing it that this is actually not necessarily the truth of the matter. It's more of us having fun. So all of that becomes really, really important. And what this law therefore will do could even go to aspects like, you know, protecting your sources. You know, someone could give you credible information, but they don't want to be stated publicly, their name, because if someone does that, then their life is in danger because
Yes.
they are actually within key parts of the government. So what does it mean for whistleblowers? What does it mean for people who are actually sharing this information as activists and stuff like that? So the media becomes really, really important, and it goes to this law would have gone to the epitome of the freedom of the media, especially around independent journalism, reporting on things as they are and as they're happening. And then lastly is on the access to information. Now this, I know you're mentioning it. Someone will say, what does it have to do with this law? But what this article mentioned is that people, citizens of the country, have a right to access information.
Yes.
The analogy that we'll use is that the government has to have open doors when it comes to information.
That is true.
It's not like they're doing some secret thing that there is certain information that should be kept secret.
Yes.
But that is like, I would say, if you were saying percentage-wise, not even 10% of the information. 90% of the information, you should be sharing it in terms of what the government is doing, how they're doing things, and stuff like that. So if this information was shared in the first place,
Yes.
then citizens will not be gullible. Because if someone comes tomorrow and tells me Kenya has 47 counties, all I have to do is go to the constitution. If someone says it has 50 counties, I'll go to the constitution and say, actually it's 47. So
Yes.
I wouldn't be falling for that trap. If someone comes and tells me there are 4 arms of government, I just have to go to the constitution and say, actually it's 3.
Yeah.
There's judiciary, there's executive, and there's the legislature,
Yes.
and stuff like that. So if the government actually did its role and provided this information,
Yes.
without necessarily people asking for it, because this information should be there, accessible. Someone just has to either go online or go to the offices of these government departments, and they can see what's happening. And therefore, it becomes very hard for anyone to spread false information. So until we get to a point where the government has done its part of providing this information to the public, then they don't have any grounding to come in and say whatever someone is saying is not true. Because for you to say to be held that you are not telling the truth, you have to know that you're actually lying. So if you don't have the information, then it becomes very hard to prove that.
And that is the reason why I brought that Article 35, that access to information, because we will find it rough for the journalist, at least to tell the truth of the matter when they don't have the information. And the access to this information lies in the hand of the government. And in most cases, they deny journalists this access to those informations. And later on, you will see saying that these journalists are lying, journalists are not telling the truth, and then they're subjected to that cybercrime law and misuse of computer, which again, the penalties are heavy. Most of the journalists can't afford. I think that is a very good explanation from your end as the advocate or the High Court, and also as well as the human rights defender. Now, when you look at these articles, when I saw the sections that were named unconstitutional, termed constitutional by the Court of Appeal, they're strictly discouraging Kenyans to communicate or to express themselves as pursuant to the Article 33. Regardless of that, in that article, again, there are some limitations that has been put into place in the Constitution. Now, do you think that the authorities or the people who are trying to amend these laws, they are safeguarding the authority, or they are safeguarding the space, or they are creating fear, as you purport to say in the previous discussion?
It's a really, really, really good question. And I had mentioned before that it's a needed law in terms of increasingly now we're seeing cyberbullying, we're seeing people being harassed online. And I'm sure some of us have been part of it, because whatever you say, you cannot convince everyone. And they say only dictators are hoping that everyone loves them. If you want everyone to love you, you have to be a dictator, because there's no way everyone will love you.
Absolutely.
So there will always be opinions that you're holding or things that you're saying that people will disagree with. Now, this law is definitely, I would say, a good part of it actually does what it's supposed to do in terms of dealing with cyber crimes, hacking, privacy issues, online, yes, all of those become really, really important. But what's problematic is, one, there is redundancy in terms of if you're talking about things like harassment, incitations, incitement, for instance, there are already laws that are doing this. If you're talking about false information or producing false information, there's defamation laws, there's libel laws, and stuff like that. So there are already laws in place that can actually provide remedies for some of these issues that we're having. And that's why you will see that a big criticism that you're seeing on this law is that actually what it does is to try and censure people and limit people's freedom of expression and to be able to actually speak up against wrongdoings. And therefore, many people are saying it's more of supporting or servicing the authorities rather than servicing the people that the authorities are supposed to be representing.
Yeah.
So that's very, 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 very important. And that's why you will see, and the Court of Appeal agreed, that some of those crimes that the law is trying to bring are actually very broad and vague. And you know, when it comes to criminal law, any law, but especially criminal law, something has to be very specific so that someone can look at something, really understand. It shouldn't be up for interpretation where anything under the sun can actually fall to be a crime for this, because that provides ground for sort of targeting of people who are dissenting. I've already talked about the issue around self-censorship. So you don't want to have journalists where they're always worried about publishing something, always thinking that should I really publish this? And therefore, if they get to that point, then the authorities have succeeded, because it means that the people won't be having access to information, especially important investigative information about things and wrongdoings that are happening. The other bit is about the potential of it being weaponized against especially critics of government. You know, you saw, like, for example, with the protest, it's an example I'm using for protest. What they did is they now started charging people not just for protest, because if you are charged for protest, very easily the court will either give you bail on your own self, or like a very minimal amount of money that you have to pay. Now they charge you with terrorism crimes when you've actually protested. So what this will do is, now this law can potentially be weaponized, where people who are speaking up against government, be it for good reason or not good reasons, can be targeted and being charged under this law. And you've seen that the punishment is 5 million, 10 million imprisonment from between 2 to up to 5 years. So all of these are really, really, there's potential for it to be weaponized and used. Because what we should understand is that the people who are running government are not machines. They're human beings. They have interests. And therefore, if anything comes between them and their interest, you know, if they're good people, then they will definitely allow for people to speak and there won't be much dissent. But if they're bad people, then they will be utilizing these laws at their own advantage. And someone said that when you're passing these laws, normally have in your mind that the people enforcing it have in mind the people with worst intentions. Because if you're having good people with good intentions now, there will be a time where people who are coming in have the bad intentions and they can utilize this law for bad reasons. And know that once a government leaves does not mean the law stops acting. The law still remains in place. There was the issue of, and I'll speak two more and then stop there. There's the issue of privacy and surveillance in terms of this law provides in certain situations where the government can surveil you, because people should understand that whatever you publish online does not mean that it's anonymous. There are ways to track your digital footprint. So the government can surveil and know that Omar or David published this thing using this, for instance, what do they call them? The digital footprint. They will definitely be able to know where you are, which phone you are using or which gadget, what was the internet you're using. They can track you to a bare 5 meters of where you are in terms of what you're publishing. Now, the problem with this is, you know, with there might be justification for doing it, but normally our laws say that before you can do surveillance, you have to go through the judiciary, because the judiciary now becomes the litmus paper where the government comes with an application where they're saying, for these reasons, we believe that David is a bad person, so we are asking for permission to do surveillance. So that they can follow up on you. So you have to prove to the judiciary first, to the courts, that actually this person has to be surveilled. But now under this law, there might be a situation where they are doing the surveillance before they've even gone to court. And you see now the problem with this now, what stops, for instance, the topmost person in government of saying, oh, the person who's opposing me the most seems, I'm worried that these might be the strengths that he has. So he can come in with some made up accusation of saying, I'm worried this person is doing these bad things under the Computer and Cybercrimes Act.
Yes.
So asking for the surveillance to be done, not necessarily because they want to deal with that problem, but so that they can actually get intelligence of what you're doing, where you are, your movement, so that they're actually using it to their own advantage. So there's a potential for that to be done. And then lastly is what I've already mentioned, so I won't speak more to it, is the overlaps that you're seeing.
Yes.
Because there's no need to pass through a law and criminalize something that has already been criminalized somewhere else.
Yes.
Because what you're doing now is you're creating redundancy, and if there is any inconveniences between the two laws, it becomes very hard now for the people who are enforcing it.
Yes, that is very fundamental. And again, when you look at these laws and the process of amending them, it looks like somebody is trying to push something, which is exactly what you are saying. It may look like authority is behaving like they fear the people that give them those, or the people that are instructed with them those powers to do what they want to do. Now, does it mean that we were not ready for the Constitution? Because the amendment of the Constitution looks like the authority did not know what they were passing in 2010. And later they're finding out, oh, we are making a mistake. We are giving these people freedom to do whatever they want to do. And again, they are going to overpower us. So they're trying to do this by amending other sections that perhaps may now limit our fundamental rights.
Yeah, and it's good. First and foremost, we were ready because the people who are passing the constitution is the citizens of Kenya, right? And the referendum,
Yes.
there was a not unanimous, but there was actually a majority
Yes.
sort of people who passed. I think more than 70%, if I'm not wrong. And when you said that some people might be against it, some of the people who are topmost in government now were physically campaigning against the constitution, right? If you remember the Ndizi and Chungwa conversation that we had at that point. But what's important for people to understand is that most of the people who are enforcing the laws now, because 2010 is just 16 years back, right? So there are people who are also there before, pre-2010 constitution. So they're used to how things were working there before, and it was easier. Life was easier for them at that point. So you know, it's not necessarily the best of saying, but they normally say you cannot teach old dogs new tricks, right? So they are used to how things were working there. So there is that sort of still pushback in terms of getting it happening. But also remember what I said about Professor Wangari Maathai. It's not just enough that you have the laws. You have to keep pushing. You have to keep pushing, because whoever gives way, you know, like if they push and the citizens accept it, then it becomes accepted norms, and then all of a sudden people start practicing it. But the more we push back, the more we're actually taking back the ground for these laws that are really, really important to provide our rights for us to express ourselves.
Yes.
I think what's really important for people to understand is the moment you stop looking at the authority as your bosses, but more of as your servants, the more you start seeing why these laws and these articles become important for you. Because it's not them to tell us what we should be upholding. It's for us to say what should be upheld. And we've already passed a referendum that majority of us said this is what we want to be our laws that are actually sort of policing us as a community and as a country.
There's a question which is very technical. After the amendment of this law in 2025, you remember it was Amendment Bill of 2024, and then now the president has sent it into law 2025.
Yes.
Amongst the 8 laws that Kenyans really made noise about, because during the death of the former Prime Minister, right, Odinga, that is when the president, in his wisdom, signed into law these 8 laws. One of them was cybercrime and computer misuse. Do you think that the people who were taken to court and jailed because of this cybercrime law can now say, now the court has now said these these sections are now unconstitutional, so we can now enjoy our freedom? What happens when one is jailed or sentenced because of a certain breaking a law which was passed, like this act, and then later on now the act is stamped unconstitutional? Now what happens in that?
Yeah, so under our law, the good thing is there is the appeal process. If you have exhausted the appeal process, or if your time barred in terms of you didn't appeal with the time that you had to appeal,
Yes.
they can also apply for review under special circumstances. So they could go back to the initial court that had the issue and say that following the new information that came from the Court of Appeal, these two acts, these two sections of the act are unconstitutional. And because you found me to be guilty because of them, then I'm asking or begging the court to reconsider its decision on the same. So you won't automatically just be released, but you can always apply for the review. And there's a big chance
Yes.
that that review is going to be upheld, unless it's not just the only reason why you are in prison. Because you see, like there might be 10 different things that you infringe. And therefore, because two are not working anymore, it doesn't mean that the 8 now stop.
Yes,
So
yes,
perhaps the best thing that will happen is maybe they will say, because these two are no longer in place,
Yes.
then you are to go to jail for 5 years.
Yes.
So now it's 2 years because these 3 years have gone out of the window. Or they could say because these were the key issues, they are unconstitutional, then you're actually free and you can leave. They can even say because you've been inside, for instance, for a year and you're supposed to be in prison for 3 years, then we will consider it as term served. So you can leave because these two issues have already been declared unconstitutional. So it's a case-by-case basis in terms of what really determined and convinced the court to sentence you.
Okay. So perhaps when you exhaust, not even exhaust, but when you applied for the review or appeal and then you're successfully, will you now apply for a compensation? Now that you say, I was sentenced wrongly and you've wasted my time, and now I apply for the compensation. Can it work?
It's as I said, it's a case-by-case basis. It's a difficult thing because at that time when you were actually being in prison, this law was actually the law of Kenya. You understand?
Okay.
And normally the law does not act what they call retrogressively. So you normally come up with a law that starts working from now going forward, not going backwards.
Okay.
So they will say at that point it was illegal,
yes.
but now it is not. So the best that we could do is, yes, it was still unconstitutional at that point, but because the only person that can declare something unconstitutional is the courts, and they had not done it, then it was assumed to be the law of the land at that particular point. That's why it becomes difficult. As opposed to, for instance, someone who's been wrongfully jailed, for instance, murder, but actually they're innocent. For instance, maybe someone gave evidence that actually you did that act, there's an eyewitness, and then 10 years down the line, they come back and say, no, actually I lied because I don't like David. I said I was the eyewitness, but I was not. So you can actually now ask for damages at that particular instance.
That is good. Now, as we wind up on this cybercrime and computer misuse act, this has been ascended, and now the Court of Appeal is now saying the two sections are now out of bound because they are now unconstitutional. Now, do you think that in the process of saying that these sections are constitutional, in other way or the other, they gave an opportunity to the human rights defenders, those who love speaking out, those who love criticizing the government, those who really working so hard so that the people know what is happening. Like, for example, if I give you a political example, Gachagua said that the president is looking forward to have everything, and he's now the person which is disrupting the Nairobi hospital. I may use it as a news bite and will write on my articles as a journalist, and then perhaps it comes out that it was false, that Gachagua was just doing his politics,
doing political scores, setting political scores.
Yes. Now, do you think that this this Court of Appeal has given us a break as people who are working in this atmosphere of social media and journalism, and also the human rights defenders, who most of the time they criticize the government?
Most certainly, because the job that's being done by journalism is very important. Some people even say it's the fourth arm of the government.
Yes.
When you're having a government that is not functional, it's functional, but at least the checks and balances are not working very well. The media, the journalists become really, really important in the role that they are playing. Now, the good thing is when you're reporting something and say Gachagua said this and this, it's different than you saying actually this and this is what happened. And even when this law has been declared unconstitutional in terms of the false information, if you are a journalist and you are a good journalist and you're doing your job very well, if you now are reporting what Kachagua says, you always have to give the right of reply to the other side. So there will be attempts to reach out to Arambe House or to State House to get their comment on the issue. So you're not actually being biased in terms of what you are representing. You are checking on both sides and you are presenting what has been said. And when now, if you've done your job well, they cannot sue you. They can only sue the person who has said the wrong thing. For instance, in this case being Gachagua. And there are ways that things that they can do. They can take them to court, even if this is not unconstitutional. It's a criminal law. Through civil law, they can do defamation proceedings and stuff like that. So all these are avenues that the president has, for instance, on things that are being said against them. Or they can just make it very public and say, this is actual, because we know there's some sort of conversations that are happening on Nairobi Hospital. We know that for whatever reason, they're trying to resolve the problem that is there. Might be good reasons or bad reasons. But you see, if you're doing these things behind the curtain,
Yes.
you should always assume that the reasons will be bad. Because, you know, if someone talks about you behind your back,
Yes.
very rarely do they talk about you with good intentions in mind, right?
Yes.
So if you just share, if it's really good reasons, you will share it publicly, because if anything, you have everything to gain by making that information public.
Okay. So at what place does it leave the Kenyans defenders, the human rights defenders like you? Because most of the time you people are under the bus because of those criticizing the government, speaking out, and they say that you guys are against the cybercrime law. You see, so at what point now does that one, this now does this a court determination leave you as human rights defenders?
No, it's a good question, and indeed, people who have been victims a lot is people who are pushing false information that is sort of supporting the authorities rarely get arrested for their wrongdoings. You know, bloggers who are saying bad things but supporting the government of the day rarely get arrested. It's those people who are speaking up critically against.
You know, here we call them Sangwenya. In Mombasa, we call them Mungu Akuweke.
Yeah, and we have with NGOs, we have some we call the gongos. They say government-owned NGOs. You know, the NGOs who speak up. Really, you think that it's a department of the government that's speaking on a certain issue. Now, the good thing is, and as I said, it's not my duty to necessarily cuddle or love or say good things about the government.
Yes.
For me, I expect the government to do its job.
Yes.
If it doesn't do its job, then it's my duty now to show the shortcomings that are happening.
Yeah.
It's not charity, because sometimes people look at government as if it's charity, that these people are doing these things for free. It's salaries that they are receiving. We are paying taxes as Kenyans, you know, in trillions of Kenya shillings,
Yes.
and therefore you should expect something in return. You know, if you've employed someone in your business and they're not doing whatever you've agreed that they'll be doing, the immediate cause is you'll bring them to the table and tell them, oh, this and this is actually not happening in terms of what we've agreed.
Yeah.
And therefore try and figure out ways of resolving it. If it's not possible, then finding ways of cutting off and retrenching that employee. It's the same thing with the government. If the government is not providing access to the information, it's your duty as a citizen to speak up on this issue. If the government is not living up to what they've agreed that they'll be doing, then it's your duty as a citizen to speak about these issues. Okay. They could come with many reasons in terms of trying to stop you from doing it, but it doesn't necessarily mean that you should stop. And it's important for people to know that that duty of you to say when there is wrong does not now give you the license to now add more salt, you know, and try to make things even worse than they are. At least also be very responsible in how you are providing what you're calling your truth. And the other thing perhaps that's also very important is what's truthful and what's factual might be two different things. And the Court of Appeal was very wise and mentioned this. There was a time in the 16th century, I think, or maybe before, when it was illegal for you to say that the world is spherical. If you say the world is round or spherical, it was wrong, because the church believed at that point that the world was flat. So people like Galileo and the rest who are increasingly saying that the world is spherical, they were actually being arrested, because at that point they were being arrested. Everyone, the law of the land was saying it was the same. The same thing when we were in school, we were being told that there are 9 planets in the universe.
Yes.
We just learned, I think last year or maybe 2 years back, that Pluto is no longer a planet now.
Yes.
It's just something that does not necessarily have the capacity to be called a planet. So the same thing for this case. If you've not provided the information, it's not accessible. You cannot tell someone that they're spreading false information, because they don't have the truthful information for them to look up against the false information, for them to actually say something is false. Or perhaps what's being considered as truthful is false. Maybe there's falsified documentation. Maybe the government is not being truthful in sharing all the information. And therefore, you are thinking that that's the truth, but actually it's the opposite. So we have to be very careful in terms of how we do it. And that's why the Court of Appeal was very categorical that we don't punish people for saying the right thing when actually later we come to realize that they were actually being truthful.
Okay.
Yeah.
I think that could answer my question about when we were starting, you said ignorance has no defense.
Yes.
And the Court of Appeal is saying some may even spread news that they don't know, or they're not aware whether the news is true or not.
Yeah.
And now, majority of innocent people might be netted for the mistake that purportedly they didn't make. So, how do you balance the ignorance that has no defense and spreading a news which is false, and still you don't know that this news is false? For example, there's a guy in court last year that was said that he put the image of the president. I want you to explain to me this with those 2 answers, the false and the truth. No, truth and fact. And then now when his lawyer asked court to bring the person who believed that he is not this person. You understand? So could it be it is true, this image is for the president, but it's a fact that this image does not belong to the president. It is only the president who can come and say, this is me or this is not.
So they asked for the president to actually be brought to provide that testimony.
Yes.
That's interesting. It's what I heard. I'm not sure whether it's true, but it's what I heard, where the lawyers for, if you remember what happened in Shakahola with the Mackenzie, someone was asking the prosecution to provide evidence that the people who had died are not in heaven. So you have to provide that information, which is definitely very, very interesting. But what I will mention for people to use,
the same case also happened between Wajakoya and Yesu Watongaren.
Yeah. When
he asked court to produce the real Yesu.
Yes, the Jesus. Yes.
So that they can do a comparison.
Yes.
So that to wajue nani Yesu wa kamili. Kama huyu sio mnamjua Yesu Watongaren. Yesu kamili yuko wapi?
Yes, very, 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 very true. But what I will mention should be perhaps what I normally use to guide me is not every information, even if it's truthful or not truthful, not every information that's being given to you does not necessarily mean that it's worth sharing out. Normally what I do is, for instance, if someone shares a video of someone who's being found in extramarital affairs out there, I don't see how that helps the public by me sharing it publicly, like beyond just infringing the rights of privacy of this person. So for me, normally I ask the question is there a public good that we're trying to push by sharing this information out there? For instance, it's a matter of corruption where someone has misused public resources. It's a matter of certain thing that has not been done in the right way. The Nairobi hospital conversation becomes very, very important because it's a company limited by guarantee, which means it's supposed to be doing some public good of sorts. So that becomes the really, really big question that I ask. And then there's the question of, even when we're sharing the information, I'm sure you saw during the protest for the taxation beats that we are having, where people were even sharing phone numbers of people. They're saying like asalimiwe, and people were being, like trolled and getting messages and threats and all that. So not all information can be shared. My telephone number, it's true, but you sharing it out there, it's not just a defense by saying it's true. because that's private information and that should be allowed to have some privacy. It's one of our rights under the Constitution. So for me,
Article 31.
yeah, that becomes really, really important. So it's normally about criticizing, for instance, policies or actions by elected representatives, because also for our elected representatives, they have to realize that once you get into a public office, you're no longer a normal, ordinary citizen. More is expected of you and more will be said of you. So if you're one of those people who anything that's being said against you, I'm not saying we should say anything against you, but even trivial of issues make you become really problematic. I'm sure you remember under the Kibaki government when people were reporting that the president had two wives, and it became a big issue, including going to the media house, including calling a public conference, among others. So you need to accept that you will have more light spotlighted on you, and the sad thing is that none of us is 100% pure. We all have our own small skeletons that we are hiding on the closet. So if you don't want yours to be brought to public, don't come to the public office.
Because you become a duty bearer. Perhaps you are not ready for that.
Yeah.
So as we close up now, this is with the parting shot. Why do you think, or what can you tell Kenyans for them not to be on the wrong side of the law, of specifically this Cybercrime and Computer Misuse Act? What should they do and what should they know so that they cannot, you've said so much, but in summary of just a minute, what would be your parting shot on that matter?
Yeah, so the first thing they need to understand is that as citizens of this country, we all have rights. And these rights including freedom of expression, including rights to privacy, and including right to fair trial. So any laws that are coming up to try and limit some of these rights is not so that you cannot access and enjoy these rights. It's just to make sure that we enjoy these rights responsibly. Because normally we say that your right ends where mine begins.
Yes.
So if you're enjoying your freedom of expression, it stops at you, saying untruthful things about me. And there are ways for me to enforce that. Now, the bottom line really is that before you post, share, forward, or do anything online or even in real life, you need to think first before doing it. I'm not saying stop, but think in terms of what am I trying to do with sharing this. So that if you're actually trying to push for a public good, where by sharing this information, it's not just about hits and likes and retweets and I don't know what, but it's actually about me providing information that is very important for the public to make key decisions, then by all means share it. If in any way you're actually creating more harm than good, then I will definitely ask you to try and refrain from sharing it, because the law might catch up with you in terms of that. The other thing is to make sure you verify the information that you receive. Like me nowadays, what I normally do is when I see something, the first thing I will do is go to some of the big media houses in the country and see have they reported on this issue. Because I've seen many a times, gazette notices where I'm being told tomorrow is a public holiday, don't go to work. And then all of a sudden I decide not to go to work and I get fired. And I say there's a public gazette notice here, but someone actually just photoshopped it and shared it online. So verify, because there are ways of checking. I'm not saying do all the research, but at least do enough due diligence where you can say, I tried to try and verify.
I remember when the news broke out that Baba has died, I received more than 10 calls from people that, David, kindly please confirm to us, is this news true or false? So I was also not privy to the information.
Yes.
So I switched on television to see whether Baba is dead or not.
Exactly.
So after confirming is when I make those calls and then tell them, no, the Baba has gone.
Yeah, because you can kill someone and someone is actually still breathing. And what would that have done to you as a journalist? If you said, yes, he's dead, and then he's actually still alive, whatever now you say after that, whatever news you report, no one will believe you now anymore. Because, it has gone to your credibility.
Yes.
But then important also is on privacy and dignity. Don't just share any information. Please be very careful of people's privacy. Don't just forward people's phone numbers, people's emails, people's addresses where they're staying. If anything happens to that person, you can actually be charged as one of the accessory, or at least someone who's contributed to that wrongful thing happening to them. What's really important for people to remember is that whenever you are online, definitely your actions could harm someone if you are not responsible. It could mislead the public. Where someone believes something you've said, actually it has not. But then it could also tarnish your reputation, because once you've said something you cannot take back, no one will believe anything you say after that. As a journalist, as someone who's respected in public, it could go to your credibility. And then lastly also is on the issue of privacy. So whatever you say could actually go to people's privacy. Like, for example, like even using your partner's phone, like breaking into their WhatsApp and checking their things and starting to send messages. That includes as one of the false information and some of the cyber crimes things that you are doing. Knowing someone's password and sharing it with other people. All of this could be, it's part of hacking, and it's part of getting access to people's gadgets without their permission, right? So it does constitute a crime, and you might find yourself.
These information will just go directly to women. Knowing your password is a criminal offense, and they can be charged. Asante sana wakili, imekuwa nzuri, nimefurahi sana. Nafikiri tumezungumza mengi sana kuhusu masuala ambayo yanahusu katiba yetu, kipengele 33 inayozungumzia uhuru wa kuzungumza au uwezo wa kujieleza, na vile vile uhuru wa media, vyombo vya habari, na vile vile pia nafasi ya kuweza kupata taarifa kwa maana ya access to information. Hiyo ni kipengele 35. Tulikuwa tunazungumza hayo ili tuweze kufahamu fika kwamba tunapofanya mawili matatu katika masuala ya kulinda private, tunahitaji kwa Kiswahili
si kuna hakika, lakini nitasema usiri labda. Nitasema usiri.
Nataka kutumia usiri, lakini unajua natoka Migori, so I must be very careful. So kwa sasa tutasema ni asante, pongezi kwa kuzidi kutegea The Legal Mind. Here we bring you whatever you want to know concerning law. And remember, The Legal Mind, it is where the law meets politics of the day. My name is David Otieno.